Hello and welcome to The View from Mayer Brown Employment Law Christmas Podcast. This is an addition to our normal fortnightly podcast series for employment lawyers and HR practitioners, which highlight developments in case law and legislative changes of importance for UK employers. This Christmas podcast series is presented by Nicholas Robinson, the head of Mayer Brown's London employment team, and Miriam Bruce, the senior associate in that team. The podcast series aims to identify the 12 most significant cases, in the opinion of Nicholas and Miriam, to have been decided during 2017 in the field of employment law.
Hello, and welcome to the 12 Days of Christmas Mayer Brown Employment Law podcast. Hopefully, as you can tell from the new voiceover and the rather different Christmas music, we're doing things slightly differently over the next couple of weeks. In the past, we have tried to do a different episode for the podcast for Christmas time, and we thought we'd do something out of the ordinary this year as well. Who can forget those delights, such as the Employment Podcast Mashup, which we did a couple of years ago, or the one that we did 4 or 5 years ago now, which was Songs for Employment Lawyers. I'd recommend anyone who is tempted to learn that awful song-related puns are a speciality of employment lawyers, go back and listen to podcast number 13, and especially the last 5 minutes of that podcast. It's a little bit painful. Anyway, over the next 12 days or so, we're going to be counting down the 12 most significant cases, in our humble opinion, that have come up during the course of this year. Spoiler alert, not all of them have previously appeared in the podcast. Each of the episodes is going to be slightly shorter because we're going to just deal with one case, and we'll put out over the next 12 days or so 12 podcasts. At least that's the plan. Also, in order to shake this up slightly more, I'm going to have a co-presenter for this series, and I'm delighted to be joined by Miriam Bruce, who is a senior associate in the employment team and has worked in the team for many years now. Hi, Miriam.
Hi, everybody.
Miriam gets to choose 6 cases, and I get to choose 6 cases. And the first case up is going to be one which Miriam chose as her case. We did debate whether I could source the Top of the Pops theme tune music for the countdown, but I suspect there are still intellectual property rights associated with that, and my very rudimentary guitar playing is not up to recreating that sound itself. I should say the voiceover is by another of our solicitors, Tanem Taskin, and I would defy you to know from the professional tone of her voice that 2 minutes before recording that intro, she'd just seen snow for the first time and was very excited about it. Anyway, on with the show. Miriam, what's your first case for us?
So the first case I've picked is one about disability discrimination and psychometric testing, the case of Government Legal Services and Brooks. So, as we know, under the Equality Act, it's unlawful to discriminate against someone for something arising from their disability. It's possible to justify such detrimental action, but the employer has to show that this is a proportionate means of achieving a legitimate aim. Secondly, of course, we have the well-known obligation on employers to make reasonable adjustments on practices which adversely affect a disabled individual. So on the facts of this case, the claimant had done a law degree and wanted to join the Government Legal Services as a trainee solicitor. The process for this requires the individual initially to sit a number of multiple choice tests. In this case, the claimant made the GLS aware that she suffered from Asperger's syndrome and that she considered the multiple choice format disadvantaged her. She asked if she could instead submit short written answers to the questions. GLS refused, for reasons which I'll come back to, but they did indicate that if she got through the initial tests, then maybe some additional time could be granted for the subsequent stages of the process. She sat the test and she failed, and it looks like she failed by a relatively narrow margin. She claimed that there had been a failure to make reasonable adjustments and that she'd been treated adversely for matters arising out of disability, and that this was not justified. In front of the Employment Tribunal she won, and GLS ended up appealing to the EAT. At the tribunal stage, they found that medical evidence was inconclusive, with evidence going either way on the issue of whether or not she suffered a disadvantage because she had Asperger's. In the end, however, the tribunal felt that there was a sufficient link, and accordingly, subject to justification, there was discrimination, and the issue was then whether it could be justified. Similarly, a reasonable adjustment should have been made, but wasn't. At the end of the day, the tribunal decided that GLS had not justified the discrimination arising from her disability or the failure to make a reasonable adjustment, and so found in favour of Ms. Brooks. At the EAT stage, the first round of appeal focused on the fact that GLS tried to assert that the Employment Tribunal had gone astray by finding there had been a link between Asperger's and a detriment suffered by the claimant in sitting the multiple choice test. It was also unfair to assume that the reason she'd failed the test was that she had Asperger's, even if there was a link between Asperger's and the multiple choice format. However, the EAT accepted the tribunal was entitled to come to the decision that it had come to. The medical evidence was inconclusive, with evidence pointing to either conclusion that there was a link between the Asperger's and that it had been adversely affected by the format of the exam and evidence against it. On that basis, the tribunal was entitled to weigh up the evidence and come to the conclusion it had done so. The EAT pointed out that there was no alternative explanation put forward by the employer to show that there may have been other reasons in place as to why the claimant failed the test, and therefore once discrimination had been found and had not been justified, then that was up to the employer to show that there was an alternative explanation for the failure other than the claimant's Asperger's. When it came to the issue of justifying the use of multiple choice format tests rather than short written answers, the EAT again accepted that the Employment Tribunal was entitled to come to the decision it had come to. GLS tried to argue that multiple choice format reflected a core competency for the job, i.e. her ability to take effective decisions. However, the EAT didn't feel that this necessitated the use of a multiple choice format. They accepted that operating a different type of test would be less convenient with extra expense for GLS, and it would involve an element of subjective assessment in a test that was designed to be clearly objective. However, by itself, this didn't justify requiring her to sit a multiple choice format once there had been a detrimental link established to the Asperger's. So my view of this case is that it potentially has wider impact. It's not unusual to find employers screening initial applicants by using multiple choice tests. Indeed, in some ways, they can be seen as rooting out the sort of unconscious discrimination that subjective assessments might involve. So one can understand here that the employer might have felt that it was better to maintain a common approach. However, I think the tenor of this decision is quite clear. If it's a case that it's going to be inconvenient or it's going to involve some extra expense, then the tribunal is simply not interested in that as justification. If you could argue that the multiple choice format somehow mirrored the job which the individuals are expected to do, and accordingly, with the best will in the world, if they could not manage a multiple choice test format, then they were not suitable for the job in question, then that might be the justification needed, but that wasn't the case here.
Okay, I'll tell you what struck me when I was looking at this case, because I remember us discussing it in the group. You got something that on its face was a completely objective, dispassionate, tick box, yes or no, binary decision making process, and the tribunal has come along and said actually by itself that was creating discrimination. So you have an employer setting out to have a completely objective process being met with the tribunal saying, no, you need to exercise a degree of discretion and flexibility. And so the
it's an unusual outcome, I think, in that respect. I think it requires a bit more subtlety on the part of employers, not to just simply think that on the face of it this looks fine. Actually, you need to think in a bit more detail about what the impact might be for someone like the claimant in this situation.
You need to consider the potential for discrimination and then act accordingly. It's not as simple as this is completely objective and therefore it can't
we're fine,
be. Yeah. Indeed. Okay, well look, that's our first case in our Christmas podcast series. Stay tuned for the next case, which I think will be one of my choices. And we will be back tomorrow with that episode. Thank you and goodbye.
So that was our latest podcast episode. We hope you find it useful. If you have any questions or comments, please email Nicholas at nrobertson@mayorbrown.com. Our podcasts are an overview of cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thank you again for listening. Hello and welcome to The View from Mayer Brown Employment Law Christmas Podcast. This is an addition to our normal fortnightly podcast series for employment lawyers and HR practitioners, which highlight developments in case law and legislative changes of importance for UK employers. This Christmas podcast series is presented by Nicholas Robinson, the head of Mayer Brown's London employment team, and Miriam Bruce, the senior associate in that team. The podcast series aims to identify the 12 most significant cases, in the opinion of Nicholas and Miriam, to have been decided during 2017 in the field of employment law.
Hello and welcome back to the Mayer Brown Christmas Employment Podcast series. We're talking about the top 12 cases for the year. Miriam, Bruce and I are both choosing 6 cases. I'm delighted to be joined again by Miriam.
Hi everybody.
And the case today is one of my cases. It's NHS 24 and Pilar. This case relates to an unfair dismissal claim where the employee objected to certain material being put into an investigative report, which then went on to the disciplining manager. The background to the case is the claimant was a nurse working for NHS 24. Work involved taking telephone calls from members of the public and then taking a decision on the most appropriate clinical outcome for that caller. There was an incident in December 2013 which NHS 24 identified as a patient safety incident, PSI. She was dismissed. At the time of the incident, the claimant had been responsible for 2 earlier PSIs, one in 2010, one in 2012. After the 2010 PSI, the claimant was put on a development plan, but she was not told that a repeat by her of similar conduct could potentially have disciplinary consequences. After the incident in 2012, she was again required to follow a development plan, but didn't face disciplinary action. I don't think that the earlier PSIs were absolutely identical, so the issue was that there were earlier PSIs, but not necessarily identical PSIs. The investigating manager, looking at the 2013 incident, prepared a management report for the disciplinary manager and included information about the 2 previous PSIs. The Employment Tribunal, hearing the claim, felt it was unfair to include material related to 2 previous PSIs because they'd not been the subject of disciplinary proceedings themselves. It would have been acceptable to have included information on the training and development plan following the PSIs, but not the detail of the PSIs themselves, according to the tribunal. So the Employment Tribunal said the investigation had not been conducted fairly. On that basis, the Employment Tribunal decided the dismissal was unfair. It was also found to be unfair by the tribunal because the employer hadn't been sufficiently transparent with the claimant to alert her to the fact that any repetition of such behaviours might result in a disciplinary process. The Employment Tribunal decided that the decision to dismiss itself, the dismissal decision itself, was fair because it was reasonable for the employer to treat the matter as gross misconduct. Well, the EAT overturned the decision and upheld an appeal by the employer, and they said that the dismissal was in fact fair. First, the Employment Tribunal had accepted that a decision to dismiss, in the circumstances of the 2013 PSI, would have been fair. In other words, it was the inclusion of the earlier incidents in the investigatory report that had made the 2013 decision unfair. It was perverse to find the dismissal unfair on the basis that the 2 earlier PSIs had been included, according to the AT. The job of the investigator was to assemble information for an investigation report. It was not up to the investigator to decide on what weight to attach to particular pieces of evidence. Equally, the BHS and Birchall case requires an investigation stage to be sufficient. And the EAT accepted, in theory, there could be unfairness caused by an overzealous investigation process, but that wasn't the case here. Secondly, the EAT pointed out they were not considering whether it was unfair to take into account the earlier PSIs in deciding to dismiss the 2013 PSI. The tribunal had accepted that did not make the dismissal unfair. Separately, the EAT accepted that the claimant hadn't been given any expectations either way about what would happen if there were further PSIs, and so that ground of appeal succeeded too. I wanted to include this in the Christmas list because the case looks at an aspect that doesn't come up that often, but it is an important one. What should go into a pre-disciplinary investigative report? Normally, of course, if there's a challenge to an investigative report, it's because it's not been thorough enough, or it's left out things the employee says should have been included. But here, it was the allegedly irrelevant stuff, in the view of the claimant, that made the decision to dismiss challengeable in her opinion. I think overall it's a useful lesson for employers. You do need to think, if you're commissioning investigation ahead of a potential disciplinary action, does material properly belong in the investigatory report, or will it skew the disciplinary decision so the whole thing becomes open to challenge? If irrelevant material is included and then relied on, well, potential claim. The danger for companies that a disciplinary manager may feel he or she is entitled to take into account any material in the investigative report. It's in the report after all. Well, the AT's decision makes it clear that the investigator's report is to assemble potentially relevant material and evidence, but it's for the disciplining manager to decide what is relevant to the outcome of the disciplinary hearing. So, as I say, that's why I put the case into this list, because although it's an slightly unusual set of facts, I do think it's quite a useful lesson for employers.
Do you think it means that employers need to be giving more guidance to investigating officers in their role? Because I think often the case, the focus is on the dismissing officer.
We've certainly seen that, where they may think to give the dismissing manager guidance, but you're often doing it off the back of an investigatory report that has been written, sometimes on the basis of, well, if we're uncertain about whether it's relevant, we'll include it. And you can understand how that becomes the case, because often, as I say, there's a complaint that we didn't include something that was relevant, and so the disciplining manager didn't know it. But I think it would be quite sensible for investigatory managers to know that there may be certain material that should not be included, because if it was to be taken into account, it would clearly be wrong. I think, yes, I agree with you entirely. I think that would be a sensible way of doing things. Okay, so thank you very much for listening. That's the first of my cases for the top 12. We'll be back again tomorrow with Miriam's second choice. But until then, stay safe, and we look forward to catching up with you tomorrow. Thank you, goodbye.
So that was our latest podcast episode. We hope you find it useful. If you have any questions or comments, please email Nicholas at nrobertson@mayorbrown.com. Our podcasts are an overview of cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thank you again for listening. Hello and welcome to The View from Mayor Brown Employment Law Christmas Podcast. This is an addition to our normal fortnightly podcast series for employment lawyers and HR practitioners, which highlight developments in case law and legislative changes of importance for UK employers. This Christmas podcast series is presented by Nicholas Robinson, the head of Mayor Brown's London employment team, and Miriam Bruce, the senior associate in that team. The podcast series aims to identify the 12 most significant cases, in the opinion of Nicholas and Miriam, to have been decided during 2017 in the field of employment law.
Hello and welcome to the Mayor Brown Christmas Employment Podcast. I'm back again today with Miriam Bruce.
Hi everybody.
And it's Miriam's second choice in the countdown of top 12 cases for employment law decisions during 2017. So Miriam, what's your second choice?
So my second choice are two cases related to dress codes. So there's been a lot of comment in the press this year about dress codes. We all remember the furore created when a female employee who was allegedly sent home by PwC for not wearing high heels. So I've therefore picked two cases which focus on dress codes in the workplace, albeit the cases I've picked relate to the wearing of a Muslim headscarf or hijab to work rather than high heels. The cases I'm referring to are the ECJ decisions in Achbita and G4S Secure Solutions, and I'm going to get this wrong now. The second case is called Bugneo and Micropol, which I shall refer to as Micropol.
Can I just say, interrupting at that point, I didn't know how to say them either when I was doing the podcast.
Okay, that makes me feel better.
I think your pronunciation is probably more accurate than mine. Anyway, on you go.
On I go. So both cases concerned on differing facts an individual female Muslim employee who wished to wear a hijab at work. In both cases, this was not permitted by the employer, and both employees were dismissed. In the Achbita case, taking that first, the employer was arguing that it had a practice of religious neutrality. All religious symbols and political and philosophical symbols were banned. This was on the basis that the company wished to be completely neutral in relation to its customers, suppliers, and so on. The ECJ took the view that there was no evidence that this policy had been applied differently to the claimant. If the rule were applied neutrally, then this was not direct discrimination, this was indirect discrimination, because all employees were treated equally. It would be the impact that would be different, given that such a ban would disproportionately affect followers of a particular religion. In that case, it would be necessary to look at objective justification. In general terms, the ECJ said that if an employer wanted to project a neutral image towards public and private sector clients, this could be a legitimate aim. It would be necessary to consider whether it was genuinely pursued or whether it was applied fairly and consistently. They didn't indicate that it might be necessary to consider whether the policies applied to all employees or whether it was only those who had interaction with external third parties. If the policy applied only to those who had external-facing roles, then this could be potentially a justified policy. It did, however, flag up the prospect that the employer should consider whether to move an individual who's suffering pursuant to such a policy to a non-external-facing role. In the second case, Micropole, the court acknowledged that it was not clear whether there was such a neutrality policy being applied or whether instead the employer was relying on adverse comments from a customer. Interestingly, the court accepted that if the dismissal of the individual was based on a customer's unwillingness to be served by someone wearing an Islamic headscarf, this would amount to direct discrimination. The concerns of a particular customer would not be a justification for direct discrimination. So I think what's helpful from these cases is the comment that individual customer or client preference would not be an acceptable defence to a direct discrimination claim. Here it wasn't acceptable for the employer to dismiss an individual simply because a customer was unwilling to be served by an individual wearing a hijab. What, however, is more troubling is the court's approach to the application of an alleged policy on neutrality. I think one possible view of the judgment is that it's now acceptable for employers to claim, whether on a whim or otherwise, that they have an internal policy of neutrality which makes it justifiable to refuse to employ or to dismiss, for example, a Muslim who wants to wear a hijab. Equally, you could see a scenario where, in reliance on this case, a man who has a beard for religious reasons is dismissed, but someone who chooses to have a beard for personal reasons isn't. These potential outcomes would seem to be disproportionate to me and not giving sufficient weight to either an individual's rights under the European Convention on Human Rights to manifest their religious belief, or the desire to have a modern, diverse and plural society. There will no doubt be other cases on dress codes to come, and I'd expect an English employment tribunal to take a closer look at justification for such a policy and its proportionality.
Tell you what's really interesting about this case, and it's a juxtaposition. Yesterday evening, Mayor Brown's LGBT plus group had sponsored a talk given by Nigel Owens to Mayor Brown's clients and partners and so on. And it was a really fascinating talk. If anyone gets a chance to hear Nigel Owens talk, it's incredibly powerful, incredibly moving. But he was talking at one point about bringing your whole self to work. And this case and what it says about neutrality seems to cut across it. Now, it's not saying employers should have neutrality, but it's saying employers can have neutrality. And in one sense, you can understand that actually may enable people to bring around diversity. But on the other hand, it seems incredibly artificial to expect employees to refrain from anything which indicates orientation, religious beliefs, etc. Something as simple as putting photographs of your nearest and dearest on your desk is a statement about potentially sexual orientation or religion or what you do at weekends or whatever it is. And so I wondered whether you had a sense that maybe English employment tribunals might take a different approach to the idea of an employer saying, I am not doing this because I want a policy of neutrality. Whether you think English tribunal would expect a more nuanced or good reasons for a policy of neutrality rather than just, I want a policy of neutrality.
I think you would expect a more nuanced approach, and I have to say I was quite surprised by this decision, particularly given the cases of Ouida and
Yes.
the previous approach that the European courts have taken. It seems, as you say, slightly artificial in the real world to take such an approach. But
Do you know what? It strikes me there's a bit of a parallel between this and the Government and Brooks case that you mentioned. Something that is ostensibly completely neutral. We will wear a uniform at work, so there is no possibility of treating anyone differently has a disproportionate effect. And in this case, the court said, OK, it's neutrality.
That's fine.
Whereas Government Legal Services and Brooks, they were saying, no, you need to have a more nuanced analysis about the impact. So,
I agree, interesting analysis.
yeah, and just talking just now, that parallel occurred to me. So, anyway, thank you very much indeed for listening. Tomorrow we're back with one of my cases. Until then, stay safe and talk to you then. Goodbye.
So that was our latest podcast episode. We hope you find it useful. If you have any questions or comments, please email Nicholas at nrobertson@mayorbrown.com. Our podcasts are an overview of cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thank you again for listening. Hello and welcome to The View from Mayor Brown Employment Law Christmas Podcast. This is an addition to our normal fortnightly podcast series for employment lawyers and HR practitioners, which highlight developments in case law and legislative changes of importance for UK employers. This Christmas podcast series is presented by Nicholas Robinson, the head of Mayor Brown's London employment team, and Miriam Bruce, the senior associate in that team. The podcast series aims to identify the 12 most significant cases, in the opinion of Nicholas and Miriam, to have been decided during 2017 in the field of employment law.
Hello and welcome back to the Mayor Brown Christmas Employment Law Podcast. I'm joined again today by Miriam Bruce.
Hello.
And we're talking about one of my cases this time round, which is the case of Green and SIG Trading. I can't read my own handwriting now. SIG Trading Limited, which is an EAT case on territorial jurisdiction. I think the case is important because there's no doubt that the interplay between competing potential jurisdictions, well, it's a key battleground. We've just come through a case acting for a client where an LLP is facing a claim from a member of the LLP living and working in another European country but wanting to bring a claim in England. In what circumstances are they able to bring claims in England? What circumstances can they only bring claims in the country in which they worked? You can very easily see how this is a question of absolutely critical importance for many employers, many LLPs. Well, in this case, the employer is a UK registered company and a subsidiary of a UK PLC. Claimant was the managing director for the business in Saudi Arabia, married to a Lebanese national, lived with his family in the Middle East for over 15 years, took up the post in May 2014. Continued to live in Lebanon, working in Saudi Arabia for 2 to 4 days at a time. The company, as employer, paid for his accommodation. He did register for tax in the UK, but was regarded as exempt for UK tax or national insurance. And the claimant's contract expressly stated that it was governed by English law, referred to English employment legislation, and English policies on things such as anti-bribery and corruption. And it had a UK mobility clause covering the UK and Ireland, which was obviously spectacularly irrelevant. He was given a standard UK employment contract because it appears the company didn't have any operations outside the UK prior to this, and that was the template contract to hand. It was also decided that it was an important part of the job that the claimant was based in Saudi Arabia, because previous attempts to develop business in Saudi Arabia with an employee working remotely had not been successful, so the tribunal accepted that there was that link to Saudi Arabia. Well, the tribunal agreed that the budget for Saudi Arabia was an independent item within the UK budget and was administered separately from the UK budget. So again, there's another Saudi Arabian factor. Well, claimants made redundant. Since the only management in the company was based in the UK management, and in particular the UK HR director, handled the redundancy. The claimant then brought claims in the English Employment Tribunal and was, of course, met with a defence. The tribunal can't hear your claim because it doesn't have jurisdiction. The Employment Tribunal agreed with the employer and said that the comparative exercise showed that the connection with Great Britain and British employment law was in the minority. And so the Employment Tribunal found as well that the contract of employment, which was explicitly governed by English law, was for convenience only. Well, claimant appealed to the AT. Now, take a moment, think about the law here. The law underlying this, of course, is there's nothing expressed in the Employment Rights Act as to territorial jurisdiction. We've had a whole series of cases, Ravat, Duncombe, etc. We now know it's clear that employees who are working or based abroad have to show a sufficiently strong link to Great Britain and British employment law to grant jurisdiction. The early cases dealing with this extraterritorial jurisdiction took quite a tough line on this and said it would only be exceptionally that this would be the case. This seems to now have been watered down, as I say, to being a quote-unquote sufficiently strong connection. However, there still needs to be a strong connection, however you phrase it. The question here was, could the claimant show there was a strong connection to Great Britain and, separately, British employment law? Well, the EAT said it was not open to the Employment Tribunal to discount the existence of a clause applying British law to the contract of employment by referring to the employer's subjective intentions. It was a fact, plain and simple. The parties intended to apply British law to this contract of employment. That hadn't been disputed. It couldn't be disputed. As such, that was a significant factor pointing towards the Employment Tribunal having jurisdiction. Therefore, the EAT decided to send the matter back to the Employment Tribunal to reconsider this, taking into account the existence of the clause as weighing in favour of finding the Tribunal had jurisdiction. So, I think the learning point from this is pretty clear. Here we have an individual who was employed by a UK company, lived and worked entirely outside the UK. It was essential for the contract he was actually based in Saudi Arabia. He'd been living outside the UK when he was recruited. Set against this, there's a standard form contract expressly applying British, I assume English law, to the contract, and an English management team to whom he reported and who gave notice of termination when the time came. However, the tribunal had found, and was entitled to find, that that was simply pragmatic, at the management dismissal point, on the basis there was no one else around who could handle the redundancy. So the reality is, the two links to the UK, and really the only two important links, one, there was a UK employer, and two, there was an English law clause in the contract of employment. And the EAT sends the case back to the tribunal because of those two factors, and could be sufficient to give the English tribunal jurisdiction. Now, I think that's pretty far from showing there's an exceptional link to the UK, but that's the law. So, if you are employing someone and you are a UK company and you're employing them outside the UK, you need to think very carefully about whether to put them on an English employment contract. It's not possible to put them onto an English contract and disapply English statutory protections. I've seen that attempted several times. Here, the EAT made the point that statutory protections will apply irrespective of what the parties say in the contract of employment. If there is an especially strong link, then the statutory protections will apply. That must be right. So I think it's going to be necessary to consider in each case whether to have local law applied to the contract in question, or whether there are advantages in having someone signed up to an English law template. And if you have an English law template, you may find that it may be prudent to assume that you're going to treat them as if they were covered by English statutory law, e.g. for the purpose of unfair dismissal, if you're going to dismiss them in circumstances where a claim might arise. So that's the case of Green and SIG Trading Limited.
There's interesting parallel, I think, with the worker cases, because in which you're going to talk about, I think, later in the 12 days.
Spoiler alert.
Where the court is very willing to look behind the contract, whereas in this case it seemed that they were swayed quite heavily by
just the formality of the contract. Yes, I agree. Although I suppose if the test is, can you show a sufficiently strong link with English employment law and English and England and Wales jurisdictionally, then I think that it's difficult to argue there isn't a sufficiently strong link with English employment law when you've got an English employment law contract. So it's just a crossover into a sufficient tie-up with England and Wales in itself to matter. So thank you very much indeed for that, and we'll be back again tomorrow with the next of our cases in our series. Until then, take care of yourselves, and we look forward to speaking again to you tomorrow. Goodbye.
So that was our latest podcast episode. We hope you find it useful. If you have any questions or comments, please email Nicholas at nrobertson@mayorbrown.com. Our podcasts are an overview of cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thank you again for listening.
Thank you.
Hello and welcome to The View from Mayer Brown Employment Law Christmas Podcast. This is an addition to our normal fortnightly podcast series for employment lawyers and HR practitioners, which highlight developments in case law and legislative changes of importance for UK employers. This Christmas podcast series is presented by Nicholas Robinson, the head of Mayer Brown's London employment team, and Miriam Bruce, the senior associate in that team. The podcast series aims to identify the 12 most significant cases, in the opinion of Nicholas and Miriam, to have been decided during 2017 in the field of employment law.
Hello and welcome to the Mayer Brown Employment Christmas podcast series. I'm joined by Miriam Bruce.
Hi everybody.
And we're talking about the third of Miriam's cases today. In fact, I think we're talking about a pair of cases, but it only counts as one selection.
That's right.
You are cheating mildly.
It's another pair of cases.
It's a pair of cases. All right, fine. So Miriam, what are we talking about today?
So the next cases I've picked are a repair, as we've said, and fortunately easier to pronounce than my dress code cases. So I'm looking at the cases of Ali and Capita Customer Management Limited, and the second case is Hextall and Chief Constable of Leicestershire Police, both tribunal cases. And both cases dealt with the issue of whether or not it's possible for a man to bring a direct discrimination claim based on the fact that he receives non-enhanced statutory parental leave pay, when a woman on maternity leave for that period would receive enhanced maternity pay. Before going any further, it's important to appreciate that we're talking about enhanced maternity pay and the possibility of enhanced shared parental leave pay. So the background is that it's possible now for couples to share parental leave so that it's no longer necessarily the woman who gave birth who is taking time off and receiving maternity pay. A woman who fulfills the necessary conditions can end her statutory maternity leave period early, including her statutory maternity pay, of course, and share that with her partner. However, can a man who's on shared parental leave, who's receiving pay at the statutory rate, complain of direct discrimination if a woman on maternity leave would have been paid at an enhanced rate? In other words, if an employer chooses to enhance maternity pay, but it chooses only to apply statutory rates of pay for shared parental pay, does this give rise to a potential claim for discrimination? Well, according to the Ali case, yes it does. In that case, Mr. Ali wanted to look after his wife, who was unwell following the birth of their child. However, the fact that he would have been on statutory rates of pay rather than enhanced pay was, he said, discriminatory. The Ali case came to the view that Mr. Ali had been discriminated against on the grounds of direct discrimination. He hadn't been indirectly discriminated against. It was clear that his employer was enhancing maternity pay when it was not enhancing shared parental pay. The employer attempted to defend the case by arguing that the claimant was precluded from bringing a direct discrimination claim because it was not permitted where the advantageous treatment to the woman, here the enhanced maternity pay, was special treatment afforded to a woman in connection with pregnancy or childbirth, as set out under Section 13 of the Equality Act. Secondly, the employer argued for a direct discrimination claim there had to be no material difference between the circumstances of the claimant and his comparator. It was not permissible, the employer in Ali said, to compare a man who hadn't given birth with a woman who had given birth. Now, the tribunal in Ali was pretty hostile to those arguments. They said that in this day and age it was clear that either parent could perform the role of caring for their baby in the first year, depending on the circumstances and choices made by the parents. Excluding the 2 weeks compulsory leave period, which was accepted by all the parties in Ali as being unique to a woman, after that it was possible to make a comparison between a woman on maternity pay and a man on shared parental pay, which is an interesting point for me as I've just come back from maternity leave. The exclusion clause, Section 13 of the Equality Act, didn't prevent a claim being made. The Employment Tribunal went on to say that there was no indirect discrimination claim because this was a matter where the alleged provision, criterion or practice, the comparison of maternity versus shared parental, was directly gender-based, and so it was a matter of direct discrimination or nothing. Now, helpfully, the earlier Hextall case, when confronted with the same issue, came to the exact opposite conclusion. It said that there was no direct discrimination. It went on to say that a woman who'd given birth is in a materially different position from a man who wishes to take shared parental leave. They thought the leave periods were of a fundamentally different nature. Not least, the woman had a right to maternity leave, whereas a man only had an ability to take shared parental leave with the consent of his partner. Maternity leave could be taken before childbirth, whereas shared parental leave could only happen after the child was born. They said that a more valid comparator would have been a woman who was the wife of a civil partner or a woman who had just given birth taking shared parental leave. In both Hextall and Ali, of course, that woman would have been treated in exactly the same way that the claimant was. Now, moving away from the facts, there's obviously no statutory duty on employers to match shared parental leave pay with enhanced maternity pay. However, following these cases, employers are left in the uncomfortable position of having two conflicting tribunal decisions on whether a failure to enhance shared parental leave pay could amount to sex discrimination. As these are both first instance tribunal decisions, there's no binding decision on whether an employer should pay enhanced shared parental leave pay if they pay enhanced maternity pay. I do understand that both decisions are being appealed, so hopefully there'll be some clarity on this next year. My own view is that the direct comparison suggested in Ali is not permitted. It's not possible to make a comparison between a woman on maternity leave and a man on shared parental pay, and maybe that's just my own personal experiences coming to the fore. It seems to me that if a direct comparison can be made between a woman on shared parental leave and a man on shared parental leave, that's the comparator which a tribunal should look. To have a cross comparator, i.e. a woman on maternity leave compared to a man on shared parental leave, when there's a closer comparator at hand, I don't think can be right. Secondly, I think Section 13 of the Equality Act will continue to preclude a claim for enhanced shared parental pay. I also think tribunals will be very mindful of the fact that many employers who do not enhance at the moment will instead downgrade their maternity pay rather than extend enhancement across to shared parental leave. Obviously, many employers have already levelled up, taking the view that it's morally and commercially the right thing to do. In terms of moving forward, it seems to me that despite what the tribunals said in this case, if the correct comparator is between a man and a woman on shared parental leave, then surely there's an indirect discrimination argument here, unless that would also be blocked by Section 13. It may well do so, but it seems to me far more logical to view this as an indirect discrimination claim, which may turn on justification rather than as a direct discrimination claim. So I think it'll be interesting to see what happens on these cases next year.
So you think Hextall rather than Ali?
I'm on the Hextall side.
It feels the more orthodox approach, doesn't it?
It does.
And I agree entirely with what you say. I think a tribunal or court would be mindful of the fact that if they do say that there is a comparison, some employers will level down rather than level up. That being said, I've been pleasantly surprised by how many of our clients have effectively just assumed they should level.
I think most
that it's the right thing to do. But I don't have anything off the top of my head in terms of the number of stats of people who are actually taking shared parental leave.
I think it's still pretty low, isn't it? But more than additional paternity leave, so some progress.
Yes, well, that's some progress at least. Yes, but the question, of course, is in terms of why people aren't taking shared parental
I think it's
leave.
cultural, isn't it, as well as legal. I think it will take time for us to move perhaps to the Scandinavian way of doing things, where it's much more seen as much more normal for either parent to take time off.
But so it's difficult to argue with a scheme that gives the parents the ability to choose between themselves how they want to split their leave period. So, again, thank you very much for listening. That concludes this podcast. We'll be back again tomorrow with one of my podcast choices. And until then, take care, stay safe, and look forward to speaking to you again. Goodbye.
So that was our latest podcast episode. We hope you find it useful. If you have any questions or comments, please email Nicholas at nrobertson@mayorbrown.com. Our podcasts are an overview of cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thank you again for listening. Hello and welcome to The View from Mayor Brown Employment Law Christmas Podcast. This is an addition to our normal fortnightly podcast series for employment lawyers and HR practitioners, which highlight developments in case law and legislative changes of importance for UK employers. This Christmas podcast series is presented by Nicholas Robinson, the head of Mayor Brown's London employment team, and Miriam Bruce, the senior associate in that team. The podcast series aims to identify the 12 most significant cases, in the opinion of Nicholas and Miriam, to have been decided during 2017 in the field of employment law.
Hello and welcome back to the Mayor Brown Employment Law Christmas podcast. I'm joined again by Miriam Bruce.
Hi everybody.
And today, one of my choices, and we're going to be talking about Brearley and Others and Asda Stores Limited. And this is the equal pay case which is being pursued by employees of Asda, which gathered quite a lot of press at the time the Employment Tribunal decision was made, and then a little bit less press at the time of the EAT decision, and I'm rejoining the case at the EAT stage. The Asda case is a hearing on a preliminary issue. The Employment Tribunal decision itself is 53 pages long. Now, what I'm going to do is give a short summary of the facts. It's an ongoing case, I would strongly emphasise, and equally I can't possibly cover all the aspects, even of the facts and decision that have come through. So I'm just going to cherry pick some of the key stuff out of it. We've been saying for a number of years that equal pay is the next big thing for the private sector. The Asda case exemplifies why unions or claimant law firms with enough resources to take the fight to employers, are willing to do so. I've seen estimates, and no inside knowledge of this, but estimates that the potential cost to Asda is something in the order of £100 million. Now, let's be honest, that looks like a pretty round number to me, but if that is the sort of number, or even if it's half that sort of number, it's no wonder that claimants and respondents are actually setting out to fight this and fight every point they possibly can in connection with this. There are well over 7,000 claimants, most of them women working in retail stores in hourly paid jobs, who are claiming equal pay with men working in distribution depot. And apparently the distribution depot jobs, well, predominantly male jobs. So the claim is that the work that the claimants do is of equal value, but the comparators, men in distribution depots, are paid more than the female claimants. And it suggests this is because the retail stores are seen as women's work and the distribution depots work, it's men's work. So the question of the Employment Tribunal, and then the AT, was whether the employees at Asda stores could use employees working at the depots as comparators. That simple question masks, well, there's a host of subsidiary points. But the main ones, it's necessary to decide, can the claimants rely on the equal pay article in the EU Treaty, Article 157? Can they claim directly on that? If they could not rely directly on that, can they rely on the Equality Act 2010 and actually the equivalent provisions prior to that for some of the claims to found, if you like, a purely national claim? Well, the background is that Asda's got well over 600 stores, 130,000 plus hourly paid employees, and after more than 20 years after they set up the stores, they set up the distributions operations, and now they have 24 distribution depots with 11,500 hourly paid employees working in the distribution depots. Retail terms apply to all employees based in the retail stores. There seems to be a high degree of similarity across the stores. There are a few variations. In distribution, the picture is much more complicated. It's not as uniform in any way, because there are collective bargaining arrangements which apply to the distribution depots but don't apply in the retail stores. The Employment Tribunal started with considering the Article 157 claim. If there is a pay comparison claim, an equal pay claim, does there have to be a single source controlling the terms of the employees, the claimants and the comparators? It's not the same as saying there has to be a single employer. Indeed, cases have established that the single source can be much wider than one employer. On the other hand, on occasions, an employer can be found not to be a single source. Well, here, the Employment Tribunal decided Article 157 was directly effective and could in principle be relied on by the claimants. Asda claimed there would need to be further evidence to determine the ability to claim, and therefore Article 157 was not directly effective. This was rejected by the Tribunal. The Employment Tribunal accepted there had to be a single source for the discrimination in order for a comparability claim to be permitted, but it wasn't necessary for there to be a single employer and a single source. In other words, a single source by itself was a gateway through to being able to claim. Unsurprisingly, since Asda employed both the staff in the retail stores and the distribution depots, the Tribunal found there was a single source for the terms and conditions for claimants and comparators. The Executive Board had budgetary control for Asda, and that was sufficient for the Tribunal's way of thinking. When it turned to domestic law, the Equal Pay Act pre-2010 and the Equality Act in 2010, it was permitted for an employee in the same employment to compare themselves with an employee at a different establishment if common terms and conditions are observed. In the pre-2010 Act, they're observed either generally or for employees of the relevant class. In post-2010, the Equality Act, this was modified to apply if common terms applied generally, or as between the claimant and comparator. And the parties, in this case, accepted terms had to be substantively comparable, but the tribunal concluded there was a sufficient correlation or comparison in a broad way between the terms for retail and distribution. Case goes up to the EAT, which decided against Asda on all material grounds. The court did accept that Article 157 was directly effective, although they also accepted that it was arguable either way. But since neither party was looking to have matters referred to the European Court at this point, it was appropriate for the EAT to decide matters without such a referral. The EAT agreed with the tribunal's ruling that it was sufficient to ground a claim under Article 157 if there was a single source of pay and conditions between the claimants and the comparators were governed by that single source of pay. Here, of course, that was the Executive Board of Asda. As such, the way the EAT put it, there was an evidential burden on Asda if it was going to displace the obvious assumption that given that there's a single executive board, there was a single source for pay and conditions, and displacing that evidential burden, well, it hadn't happened. They also accepted under the Equal Pay Act employees were on common terms and conditions, and they said that's predominantly a factual matter for the Employment Tribunal to determine. I do think the case is a particularly significant one. It should not be overlooked that it's purely at a preliminary stage at the moment. And the indications are that Asda will appeal to the Court of Appeal, and so the case is continuing. But I think it's symptomatic of a potential sea change. As I say, at the start of this, we've been saying for a couple of years there's going to be significantly more equal pay claims brought in the private sector. This case is at the forefront of those. We know of others that have been brought too. This case is deciding a number of preliminary points which, presumably, will be taken to be decided law by the time the next private sector equal pay case comes along. So it's a trailblazer for other cases to follow. There's a lot of life left in this case yet, but that's why I think this is a particularly significant case. And I'm sure we'll be hearing from Asda in 2018 as this potentially goes forward to the Court of Appeal. And I'll make you a bet. You heard it here first, well, maybe not here first, but I'd make a bet this ends up in Europe at some point.
It's interesting, isn't it? Because obviously with gender pay regulations and the reporting coming in on that, gender pay and equal pay are different, but I think that's also going to focus people's minds
spur, hasn't it?
For private sector claims.
Because you're going to look at it, and for all that employers are going to say, well, the gender pay gap stats are distorted or warped because we've got different numbers of men and women at various levels in the organisation. It's such a simple thing to do, to look at those publicly available stats and go, well, I wonder if there's material here on which we could potentially base a claim. So, as always, thanks very much indeed for listening, and we look forward to speaking to you again tomorrow with Miriam's fourth choice. Take care.
So that was our latest podcast episode. We hope you find it useful. If you have any questions or comments, please email Nicholas at nrobertson@mayorbrown.com. Our podcasts are an overview of cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thank you again for listening.